In August 2022, I received a suspicious-looking notice on yellow-orange paper regarding a supposed lawsuit against Think, the company I run. Think operates PlainSite, a legal and financial information service, but had never actually been served with or even seen this lawsuit. I finally received the summons and complaint in the mail 3 weeks later. I dealt with similar kinds of lawsuits before, but this one was so weird, with claims that were laughably out there, like invasion of privacy by intrusion upon seclusion, that I found myself wondering who would waste their time filing something so patently absurd. The answer wasn't hard to find. It was right in the caption at the top of the first page in bold capital letters. Joe Johnson. That, of course, led to the next question. Who on God's green earth was Joe Johnson? From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free with no account. It really does put the world's complexity in plain sight. It's a blessing and a curse. As I'll explain, this whole story came about because PlainSite is actually pretty good at what it does. And sometimes what PlainSite shows you is that the rabbit hole goes deeper than you can possibly imagine. If you've ever been on jury duty, or maybe have just attended a court hearing, you might have been surprised, as I was, to learn that some of the most expensive lawyers in the country don't always sound that way. Often it's part of a deliberate ploy. Using an "aw shucks, I'm just a small-town lawyer who's not so good at math" approach is a decent way to at least try to appeal to members of a jury, who might bristle at someone in a fancy suit talking down to them. But there's a grain of truth in it, because most lawyers are bad at math. You know what else they're bad at? Like, really bad? Computers. I'm not a lawyer. I'm a computer guy who studied economics and fell backwards into the law. So as I began exploring the law and the legal profession, there were certain things that stood out to me like sore thumbs that all of the lawyers never seemed to be bothered by. I'll give you an example. At the top of the first page in almost all legal filings, there's a section on the left where the parties to the case put their names. The case number goes on the right. This is true in basically every court or other sort of venue in the country. The parties go on the top left. It's always on the first page and it's always below the name of the venue. But what really gets me is that no one can ever agree on the most basic thing: how to draw a box. Kindergartners can draw boxes, but not lawyers. I think what most lawyers have been trying to do for generations now is draw a box around the parties' names. You know, 4 sides, black line, often referred to by the word rectangle. Back in the day when people were using typewriters, I kinda get it. Drawing a box would be a real pain on a typewriter. Today, Microsoft Word has a text block tool and a rectangle tool. No matter which one you pick, they're both really easy to use. So maybe in 1957, you've got your typewriter and you're not much of an artist, and instead, to save time and your own sanity, you want to draw a vertical line down the middle of the page, and then a line below the party names. 2 sides of a box, at least. Fine, makes sense. But how are you going to draw that line? And what about the corner? This is where things just totally spiral out of control. Some lawyers use the pipe character, the one above your enter key. It's a vertical line. Makes sense. Others use the section symbol, which is 2 capital letter S's stylistically stacked on top of one another. It looks like the hurricane symbol that meteorologists use, and it's fairly vertical, I suppose. Closed parentheses characters are also popular. They're vertical, but obviously curved, making for sort of a bumpy line. In Maryland, I've learned, they've grown accustomed to using spaced out asterisks. Let's be frank, this is all stupid. If I had the opportunity to address a room full of lawyers at a fancy banquet, I'm pretty sure my speech would consist only of the words, "Learn how to draw a damn box, people." And that would be it. Just kidding, I'd add the word respectfully in front, making it respectfully learn how to draw a damn box, people, because the overuse of that word is endemic in legal writing, such that if you don't say respectfully, some judges might assume you are being disrespectful. So why am I harping on something that I think is stupid? Does it matter if lawyers draw a line or a box one way or another, or if they can't draw anything at all? From an aesthetic standpoint, I guess there could be those who prefer asterisks to section symbols or pipe characters to parentheses. Knowing which character is cool in a particular jurisdiction does have the effect of cluing the judge and your adversaries in to whether or not you're from around these parts. But I'm not so much hung up on the visuals. The problem is the lack of standards. There are no data standards in law that are actually enforced. None. If there were, here's how it would work. The lawsuit data would be encoded in something like a JSON file, and the presentation of that data would be handled separately, maybe by a cascading style sheet like web pages use, or maybe by PostScript, which is the page description language that underlies every PDF. This is how professional desktop publishing software and the World Wide Web have worked for decades. You always separate out content, what you're writing, from style, how it looks. The point is, either way, the box would be drawn for you by the software, and lawyers wouldn't be charging clients to evenly space asterisks in a line. Sadly, we are years away from this. Don't get me wrong, there are standards in law, lots of them. To be fair, there are some ambitious academics and nonprofits that have introduced elaborate XML schemas and other sorts of suggestions. No one uses them. Only recently did the Patent and Trademark Office start encouraging the use of Microsoft Word documents. Before that, its outdated information technology infrastructure needlessly converted every page of every patent application into a bitmap image, which made documents impossible to search without lots of additional work. For its part, the Supreme Court has weaponized fonts and page sizes for decades by mandating in its rules that you have to provide its justices, many of whom have been revealed to be corrupt political hacks, with booklets on a paper size that literally does not exist in the modern marketplace, slightly bigger than 8.5 by 11. So no, you can't just use scissors to cut standard paper down to size. Similarly, district courts and appellate courts require that filings be typeset in certain styles with certain spacing and certain margins with certain word counts. So there are standards, but they always stop short of applying to digital data, except that everyone agrees that electronic filing should involve Adobe Acrobat PDF files. I guess we can at least be thankful for that. For there to be data standards in the legal system, first, everyone would have to agree that the public is actually entitled to see the data, what's being filed in court, in the first place. But we can't even agree on that, and that's basically why PlainSite exists. Otherwise, you could just get whatever information you needed directly from the government. Congress seemed to reach a consensus when it passed the E-Government Act of 2002, mandating that the federal judiciary could only recover its costs for providing public access to legal materials. But the judiciary just ignored that. What was the public going to do? Sue the courts? Instead, the much-loathed Public Access to Court Electronic Records, or PACER system, run by the federal judiciary, upped its price to 10 cents per page instead of merely 8 cents. The actual cost of the judiciary per page is zero, so it's pure profit. In this way, for decades, the federal courts have been stealing from the public and flagrantly breaking the law. Let me say that again. The courts are breaking the law by charging you, me, and everyone you know for information that Congress has mandated should be free. And you might think, well, some committee decided that. It's not the judge's fault. But here's the thing. The Judicial Conference of the United States is the judges. That the courts steal from the American public each and every day to the tune of about $120 million per year is widely known and generally accepted. And that basic fact has had some interesting fallout, as various clever people with an interest in law have done their best to circumvent the illegal paywall. In 2009, Stanford dropout and Reddit co-founder Aaron Swartz took advantage of a pilot program run by the Administrative Office of the United States Courts that temporarily offered free PACER access at various law libraries nationwide. Aaron wrote some code that automated the process of requesting documents and managed to download 19,856,160 pages from PACER before the geniuses at the administrative office figured out what was going on. This work earned him scrutiny from the FBI, which may have been the real reason behind the later vindictive prosecution against him by the Massachusetts U.S. Attorney's Office, supposedly due to his subsequent work in an MIT wiring closet downloading academic journal articles from JSTOR, work that harmed no one and would have benefited the public immensely. Even JSTOR didn't want him prosecuted, but the USAO pressed ahead, and that wrongful prosecution led to Aaron taking his own life in 2013. Aaron's cache of PACER data became the digital foundation that PlainSite was built on, about 750,000 cases. It also caught the attention of some graduate students at Princeton who are working with Professor Ed Felton on something called a ReCap, that's P-A-C-E-R backwards, a Firefox web browser plugin which recaptured downloaded court documents that participants paid for and then immediately re-uploaded them to the Internet Archive's servers in San Francisco, where they could be accessed free of charge by anybody. When I first learned about ReCap, I thought it was magic, a truly perfect system, the modern-day equivalent of Robinhood. It was entirely legal, it cost nothing extra, and it served an incredibly important public purpose. It drove the administrative office running PACER absolutely bananas. There wasn't anything they could do about it except add more and more annoying disclaimers and extra clicks on PACER, warning people about the dangers of obtaining court documents from the public domain, where they were free of charge. In honor of Aaron, my nonprofit organization, Think Computer Foundation, funded a programming competition to expand ReCap's scope. Most law firms used Internet Explorer at the time, and ReCap only worked on Firefox, and we managed to make real progress. Then, later in 2013, hoping to make more of a dent in the problem, I started asking around at Stanford Law School to see if any law professors would help me take up the administrative office on its implicit dare. I wanted to sue over the PACER fee structure. Every law professor I talked to expressed precisely zero interest, so I decided to just do it myself. I filed a lawsuit against the Administrative Office of the United States Courts over two issues: the PACER fee structure and the completely arbitrary inability of small businesses and startups like mine to appear in court without an attorney, pro se. My rationale? In Citizens United, the Supreme Court said that corporations had freedom of speech. Yet, they were being forced to speak through proxies, expensive proxies. Expensive proxies who often had no idea what they were doing. The case was thrown out. 2 years later, a coalition of nonprofit organizations filed essentially the same lawsuit I had over the PACER fee structure, but they invoked a different law that I hadn't known about, the Little-Tucker Act, which applies to government claims under $10,000. The case went to appeal before the United States Court of Appeals for the D.C. Circuit, which read the E-Government Act of 2002 and by cherry-picking which words to interpret based on how far apart they were from each other, decided that it meant the opposite of what Congress had actually written down. Former Senator Joe Lieberman, who wrote the act, weighed in to say that they were wrong. The judges ignored him, and due to the wacky appellate ruling, after years of fighting, the fatigued lawyers on both sides sat down at the negotiating table. A settlement was reached for about $125 million, or 1 year's worth of stolen PACER profits. Years after that, the public interest lawyers representing the nonprofits decided that they were entitled to about $23.86 million of that, and the judge, somewhat unbelievably, agreed. I and about 3 other people filed formal objections, and now the case is on appeal again because one of them was even more furious than I was. PACERs still cost 10 cents per page. 8 years after that second lawsuit was filed, everyone is still waiting on checks for their share of the remaining $101 million of the settlement. Now, you might be wondering what any of this has to do with this Johnson lawsuit, and the answer is that it has everything to do with it. On September 15, 2016, at 9:54 a.m. Pacific Time, someone named Joseph Johnson filled out the PlainSite Contact Us form. The request said, "Please remove the personal email and phone number that appears on this site for the above referenced docket, as it is being used for an improper purpose. Thanks." I didn't know what the improper purpose was, Joseph Johnson didn't say, but I took a look at the case the request was tied to. It was called Johnson v. Ashmore et al. In federal court in the Northern District of Texas. In case you're wondering, et al. Is Latin that just means and others, meaning that there are others not listed. The plaintiff was listed as Joseph Johnson, Jr., and the defendants were Allison Ray Ashmore and Craig William Budner. According to PACER, the case was about a contract. I'd never seen it before. All of this case information had automatically been fetched in August 2015 from the Internet Archive in San Francisco based on data it had obtained from that magical ReCap browser plugin. That afternoon, I got around to handling Mr. Johnson's privacy request. PlainSite has a mostly automated system that generates form responses based on about 20 different factors. I decided that there was only one factor that applied to this particular request, which was the most important one. There was no reason for the case not to be public. Here's what the form response Mr. Johnson received by email said. It's a bit verbose because it quotes from a bunch of legal opinions whose names I've omitted, so you'll have to bear with me for a bit. Your request regarding Johnson versus Ashmore et al. Has been denied. Based on our research, the following factors were used to make this determination. There is a presumption of public interest to court records, and you have not identified a compelling privacy interest. Historically, courts have recognized a general right to inspect and copy public records and documents, including judicial records and documents. This right is justified by the interest of citizens in keeping a watchful eye on the workings of public agencies. Access to judicial records, however, is not absolute. A party seeking to seal a pleading or a dispositive motion, as well as any attached exhibits, must show that there are compelling reasons to do so and that outweigh the public's interest in disclosure. If you do not agree with our decision, please keep in mind that you still may have several options, including filing a motion, such as a motion to seal, before the court or administrative agency responsible for the records in question. Typically, individuals are not required to hire lawyers to file such motions, and examples are available on PlainSite. You can also consult our privacy policy to learn more about why public access to government records is important and how we make our decisions. Best regards, the PlainSite team. That email went out at 2:10 p.m. At 2:18 p.m., the PlainSite helpline account received a response from the same email address with the name J. Johnson. Please be advised that if this is not removed from your website, which contains personal identifying information, you will be subject to a civil lawsuit and will be tied up in litigation for the next year or so litigating this issue. It was clearly a threat, but I'd received a lot of threats. I wrote back, Mr. Johnson, I suggest you read the precedent linked to in the response below before attempting to file suit. We would bring Rule 11 sanctions against you, you'd owe us money, and the case should be dismissed immediately. If there actually is sensitive information in documents that you'd like to have redacted, let us know, or fix the documents on Pacer. But seeing as how we don't even link to any non-paywall documents in your case yet, I can't see how that could be the case. Now, if you think back to the litigation pyramid I mentioned in the first episode, you might recall the numbered federal rules of civil procedure. Rule 11, specifically Rule 11b, states that you can't file a lawsuit for a, quote, improper purpose, and that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. Filing a lawsuit over a public record being public would run afoul of Rule 11. And although judges are generally pretty reluctant to impose monetary sanctions, sometimes they do. It's generally a good idea to avoid being sanctioned under Rule 11. This did not seem to dissuade my new pen pal, Jay Johnson. He wrote back minutes later, Aaron, it would be up to the court to decide whether or not if your business has published personal identifying information in violation of state and federal law. You or your attorneys may argue the case that you cite in defense of the suit if you should fail to take appropriate action to remove the personal identifying information from your site. He spelled site wrong the first time. So while he sounded fairly lawyerly, he also couldn't spell. Odd. I responded, Mr. Johnson, you are incorrect. The court would never need to make that determination. Court records are public domain. We have a First Amendment right to publish them. It's that simple. About 20 minutes later, I had another response from him. Aaron, you have no First Amendment right to publish someone's name, social security number, date of birth, and other personal identifying information. It is a violation of federal and state law. It is that plain and simple, and if you wish to continue to take the position that you have without retracting the information from your website, the only avenue to resolve this dispute is to litigate it before a court and spend the next year or so litigating this issue. The idea that I was going to spend the next year or so litigating whether I could publish a court case sounded delusional to me. I told him so. Mr. Johnson, again, you are incorrect. We have every right to publish your name and contact information because you are the plaintiff in a federal lawsuit. We will redact your social security number if you can point us to it, though it is your responsibility as a litigant to redact court filings. Note, quote, I understand that if I file, I must comply with the redaction rules at, and then it had a link to the Texas Northern District website where there's a checkbox which you must check to file at all. Regardless, I don't see your social security number or your date of birth anywhere on our site. No laws are being violated. At that point, he just replied with, what is your phone number and address? Needless to say, I didn't respond. Instead, he found them himself. 2 days later, Jay Johnson emailed again, this time with a photograph of me from my personal website, fairly large in the message. Above it, he wrote, please verify that the below is accurate for service of process. Aaron Greenspan, in all capital letters. And then he put my old address. Please also confirm that Think Computer Corporation is a privately held Delaware corporation with its principal place of business at my old address, Santa Clara County, California, 94040. And finally, please confirm the service location as, and then he placed a photograph of a house that looked vaguely familiar but was not my house. Again, I didn't respond. It seemed like a bunch of hot air, and it was. It was the last time I heard from Joe Johnson. Until March 14th, 2018. Again, he filled out the PlainSite Contact Us form, and again, it was about the same case. This time, he wrote, the information that you are publishing about the above referenced case includes private information such as phone number and email address that has been used multiple times to commit identity theft. He wrote that in all caps. It is requested that you take this information down from your website to prevent further misuse of this private information. Here's the thing. Maybe it's just me, but when you've spent your entire career as a database programmer, identity theft kind of starts to seem like a joke. Obviously, the process of trying to piece your life together after someone has stolen your money is no joke at all. And that does happen to people, especially the elderly. But at the same time, the threat of identity theft to the average American is vastly oversold. Companies like LifeLock, Experian, TransUnion, and Equifax make millions upon millions of dollars just scaring the bejesus out of people who have no idea that basically all of our identifying information has been stolen, sold, and resold 1,000 times over, and most of us are fine. Now, that doesn't mean we should all be careless or ignore the responsibilities we have to redact and guard information where appropriate. I certainly try to take those obligations seriously, which is why I offered to redact Mr. Johnson's social security number when he suggested it was out there somewhere. But trying to convince me that a matter is extremely serious by putting the words identity theft in all caps is just not going to work. He filled out the form again on February 5th, 2019. Same name, Joseph Johnson. Same telephone number in the 240 area code. Same email address ending with the numbers 531. This time he specified, your website, including the information contained on it about the undersigned, is being used for improper purposes, including fraud and spam. It is therefore requested that you suppress any and all information contained in your database pertaining to Johnson v. Ashmore et al., case number 3:15 CV 02475, and the Texas Northern District Court. And then, on June 1st, 2019, he sent an email directly to me and to my father, who is a professor of pathology and immunology at Case Western Reserve University Medical School, and my mother, who works for a family business. The subject was in all caps. It said, Notice of Intent to Sue. He mistook the mail forwarding service for an apartment building and used an address for me of 340 South Lemon Avenue, apartment 6720, which, if it existed, would be an apartment just big enough for maybe a ladybug. But he got my parents' address in Ohio correct. Dear Mr. Aaron, Neil, and Miss Judith Greenspan, he began. The purpose of this email is to advise you that within the next several weeks, the undersigned intends to initiate litigation against Think Computer Corporation and Think Computer Foundation, arising out of a matter within the jurisdiction of the District Court of Maryland for Prince George's County. Should you wish to discuss a pre-suit resolution of this matter, please contact the undersigned on or before June 12, 2019. Sincerely, Joe Johnson, Post Office Box 441572, Fort Washington, Maryland, 20749. Another threat to sue. But this guy had been making threats, I thought, for years, and still there was no lawsuit. To be clear, at this point, I could have taken a different approach. I could have just given in and saved myself a whole lot of trouble. Many rational people would argue that this Johnson case being on the internet, and on PlainSite in particular, just isn't that important. It's actually a pretty good argument. It's the who cares argument. But the problem I always run into with that argument is that I care. Legal research is an esoteric field that most people don't know about until they need it. It's kind of like pharmaceuticals. You probably don't know about any given prescription medication, but when you need it, you really need it. The ability or inability to refer to a prior case similar to your own in support of a legal argument can make or break your case. It happens all the time. The legal doctrine of stare decisis, which is Latin for to stand by things decided, is probably the most revered legal doctrine there is. If forced to choose between doing things a new way or doing things the old way, judges will almost always choose the old way. So if you can find a case that says that the old way is in your favor, that's a really big deal. The industry that supplies these legal opinions, almost exclusively to lawyers, is dominated by two massive firms, Thomson Reuters, which now owns West Publishing, the creators of Westlaw, and LexisNexis. Both products are very expensive, hundreds of dollars per month minimum, which means they're priced well out of the reach of self-represented litigants, and every tiny area of the law you can imagine also tends to be an a la carte add-on. Also, both products aren't very good. Their strength is their comprehensiveness, the fact that they have digitized cases going back centuries. But I've used both, as well as Bloomberg Law, and I routinely find documents on PlainSite that are impossible to find on any other platform because they're just not designed the same way. So this is why it matters to me when I get a threat from someone like Joseph Johnson, or even a politely worded request to suppress a case that doesn't really merit it. Because when I've been in court, I've needed case opinions to cite, and they can be incredibly difficult to find. The availability of legal information matters. There's a second reason beyond stare decisis that also matters. Not every document in a case is a legal opinion written by a judge. Legal opinions are the output of court proceedings, but there's way more input. That input from the parties, motions, notices, exhibits, declarations, affidavits, deposition transcripts, contains facts, and those facts can also make or break a case. Westlaw and Lexis do a horrific job of cataloging these case documents, but that's where PlainSite really shines. And if you can find and establish that the facts are in your favor, it can save you years of complex and expensive legal argument. You don't have to take my word for it. In an undated memorandum entitled What the Practice of Law Includes, former Supreme Court Justice Louis Brandeis wrote, "Know thoroughly each fact. Don't believe client witnesses. Examine documents. Reason. Use imagination. Know bookkeeping, the universal language of business. Know persons. Know not only specific cases, but whole subjects. Can't otherwise know the facts. Know not only those facts which bear on direct controversy, but know all the facts and law that surround." Courts are people-based dispute resolution machines, but they are also libraries of facts about our society. Ensuring their accessibility is vital. I view it as my job. For just about 3 years after his June 2019 email, nothing happened as far as Joseph Johnson was concerned. A lot happened otherwise. The COVID pandemic, a presidential election, the insurrection on January 6, 2021. This company I'd been researching, Tesla, grew to a market capitalization of $1.2 trillion, dwarfing the rest of the auto industry combined. But just as I thought, Joseph Johnson had better things to do than file a lawsuit over a page on PlainSite. Then, on May 18, 2022, he was back. Almost 10,000 privacy requests had been filed between his request in 2019 and this one, but it was definitely him. He had the same email address, and it was about the same case, Johnson versus Ashmore, though this time he filled out the form as Joe, not Joseph, and his phone number was in the 301 area code. He wrote, "The following URLs, that is under the control of the PlainSite and/or Think Computer Corporation, contain personal identifiable information, PII, including name, address, telephone number, date of birth, email address, and other PII that has been compromised and used for a nefarious purpose over the internet to commit identity fraud, including attempts to use all of the PII elements to fraudulent establish credit. Pursuant to the Privacy Act of 1974, it is requested that the following URLs be blocked from further access. And then he put the URL of his cases page on PlainSite. This message, more than any of the others I had received before from him, convinced me that this Johnson guy was not serious. That's because the Privacy Act of 1974 is a law that restricts the rights of government agencies, not the rights of private citizens. It also has nothing to do with the courts. You can't file a lawsuit under the Privacy Act of 1974 because there's no private right of action. If Congress had wanted people to be able to file privacy lawsuits under that statute, it would have written one in. That was May 18th. On June 8th, he signed the complaint form DC-CV-001. At the bottom, there's a little section entitled Application and Affidavit in Support of Judgment. If you read the fine print, it says, "The attached documents contain sufficient detail as to liability and damage to notify the defendant clearly of the claim against the defendant, including the amount of any interest claimed." Then there's a certification which ends, "I solemnly affirm under the penalties of perjury and upon personal knowledge, the contents of this document are true." He signed that, too. On June 15th, 2022, he actually filed the lawsuit. He captioned it, Joe Johnson versus Think Computers Corp. That's computers, plural, which isn't the name of my company. But no biggie, the court actually fixed that for him. This is all 6 years after first filling out that Contact Us form on the PlainSite website. Once he handed over his papers for filing, well, it's kind of hard to describe what happened. The combination of sheer incompetence, carefully crafted and not so carefully crafted rules and procedures, long traditions, laziness, towering egos, greed, and abject stupidity turned something that should have been impossible into a threat to my company's existence and my livelihood. Luckily for me at the time, I didn't know any of this was happening at all. Not until 2 months later when that yellow-orange transfer notice arrived. But once that happened, it was all systems go, because Joseph Johnson knew my weakness. Even though he'd put a big picture of my face in one of his threatening emails, he ended up not suing me at all. He only sued my company instead. And thanks to 200 years of what I think is fairly characterized as garbage precedent based on hand-waving and lies about average people, that meant that I would have to hire an attorney, with the average hourly rate in Maryland being somewhere around $450 per hour, and most attorneys demanding an upfront retainer of tens of thousands of dollars. To make matters way, way worse, from the moment the complaint arrived in the mail, a clock somewhere in the legal heavens began ticking, and with each passing second, I could hear it growing increasingly loud. Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. Everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the DALL-E image prompting, that's my doing. Until next time, I'm Aaron Greenspan.